Welcome. My name is Charles Kaprowitz. I am the Executive Director for Citizen Initiatives and the Countermand Amendment. In this short video, you will learn how we can restore our constitutional republic, protecting states' rights, safely, quickly, and successfully. James Madison was an American statesman, political theorist, and the fourth President of the United States. He is hailed as the father of the Constitution for being instrumental in the drafting of the Constitution and as a key champion and author of the United States Bill of Rights. He served as a politician much of his adult life. Mr. Madison said the following: "The powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite. The former will be exercised principally on external objects as war, peace, negotiation, and foreign commerce. The powers reserved to the several states will extend to all the objects which, in the ordinary course of affairs, concern the lives, liberties, and properties of the people, and the internal order, improvement, and prosperity of the state."
State legislatures in 1787 created the federal government. The government did not create the legislatures. State legislatures reserved to themselves and future legislatures, in Article 5, the sovereign authority to amend the Constitution and modify the conduct of the federal government in order to preserve states' rights and personal liberties. It is absurd to argue that state legislatures must first get the federal government's permission before amending the Constitution. Neither Congress, including its Congressional Research Service, CRS, nor the Supreme Court have the requisite authority to define state sovereignty under Article 5.
When the legislatures ratify any amendment, it is obligatory on the courts, Congress, executive branch, agencies, and financial institutions, including the Federal Reserve, to obey its provisions. Legislatures are the final arbiters in all constitutional matters. State legislatures can restore our constitutional republic safely with the single-issue Countermand Amendment, which includes preapproved application by legislatures on Congress, preapproved countermand text by the legislatures, and a preapproved delegate resolution that binds delegates.
Citizen Initiatives and its team have been the leading authority on the Article 5 amendment process, either through Congress or state legislatures, for 40-plus years. Citizen Initiatives' mission: to help state legislators preserve and safely apply their sovereign authority under Article 5 against encroachments by Congress, the courts, the executive branch, and non-government mandates. Also regulatory agencies and delegates sent to a convention. Under Article 5, Congress is the facilitator of the amendment process, not the controller, and provides for the states a manageable transition from application to ratification. Congress is charged, however, with protecting the Constitution and will be required to convene a convention that is for proposing amendments only. When Congress proposes amendments to the states, they do so as the deliberative body that writes and preapproves the amendment before it is sent to the states. In the same way, state legislatures are the deliberative body and preapprove proposed amendments before the convention convenes for the delegates to vote on. State legislatures, under Article 5, have sovereign deliberative authority over Congress, the Supreme Court, and delegates, which assures that their collective will is obeyed by all branches of the federal government. Delegates to an amendment convention are ambassadors of their legislatures. They are not free agents.
Article 5 of the United States Constitution reads as follows: The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress.
State legislatures, having met their constitutional obligations, when 34 state legislatures make applications directing Congress to call an amendment convention, can convene the convention themselves if Congress causes unwarranted delays. State legislatures can safely amend the Constitution with single-issue amendment conventions, but they cannot arbitrarily rewrite the Constitution through unelected, unaccountable, politically charged delegates at a convention. Legislatures, as the elected deliberative body, pre-approve the text of all amendment proposed, as well as the delegate resolution that binds delegates. State legislators are the final arbiters in all constitutional matters, through to ratification. With the single-issue Countermand Amendment, legislatures can address egregious wrongs suffered by their citizens safely, quickly, and successfully. The Countermand Amendment will not change the Constitution, nor its guarantees and provisions. With the Countermand Amendment, we the people, through state legislatures, will be able to protect the Constitution against federal encroachment on states' rights and personal liberties. When 60% of legislatures countermand a law or ruling, it is automatically rescinded. The federal government can rewrite a rescinded law in a way more amenable to the states or abandon it. With the Countermand Amendment ratified, state legislatures can create legislature countermand committees. Committees are to be composed of legislators and will identify and select federal encroachment violations against their states. When a state legislature countermands a law or ruling, it will send copies to the other 49 state legislature countermand committees, inviting them to complete the same countermand. When 60% of the states countermand the same law, it is automatically rescinded. States can countermand and rescind laws, regulations, and other government and non-government decisions that infringe on states' rights. Enumerated rights, unenumerated rights in the 9th and 10th Amendments can be identified and constitutionalized with each countermand and rescission. Control of state land by the federal government, deficits, debt, taxation, non-government mandates, healthcare, energy, mining, local education, social issues, and more. The Article 5 Countermand Amendment is a new beginning for our constitutional republic. It's a single-issue pre-approved amendment by the state legislatures. Article 5 cannot become a constitutional open convention. It can only be an amendment convention. Article 5 does not allow the convening of a constitutional open convention. This flawed argument has paralyzed state legislators for 40-plus years and is directly responsible for our $20 trillion debt and estimated $150 trillion in unfunded liabilities. Every man, woman, and child in America owes $500,000 in unfunded liabilities. This is unconscionable. Only the Countermand Amendment can remedy this quickly. Article 5 allows the convening of an amendment convention for proposing amendments only. The purpose of Article 5 is to protect the supremacy and perpetuity of the Constitution and limit deliberations to proposing amendments. This is the real genius of our founders and the 1787 state legislatures. The simplicity of Article 5 was deliberate. Future legislators would retain sovereign authority to decide how to control the amendment process, but only for proposing amendments. The Article 5 Constitutional Open Convention argument is based on an erroneous claim that the transition from the Articles of Confederation to the new Constitution was a usurpation of power by the delegates over the Articles. After the Annapolis Convention failed, Hamilton and Madison asked the Confederation Congress to allow an open convention that would have the authority to amend the Articles without defining the limits at the convention. The Confederation Congress and state legislatures agreed. The Articles did not allow the federal government to function effectively, which almost caused us to lose the Revolutionary War and peace afterwards. Unanimous consent by the states was the biggest problem under the Articles. All 13 states saw themselves as nation-states and wanted to retain sovereign authority. There was no usurpation of power by the delegates. They did not force a transition to the Constitutional Convention.
Legislature sovereignty trumps convention experience, historical experience, legal precedents, and federal mandates. State legislatures alone control the amendment process, from the application to ratification, not Congress, nor the courts, nor the executive branch. Legislatures don't need permission from the federal government to apply for and convene a convention, as long as the purpose is to propose amendments. Simultaneous, multiple, single-issue amendment conventions are allowed in Article 5. Article 5 delegates are not equivalent to the founders. They are ambassadors of their legislatures, not free agents. The founders, who were delegates, were commissioned to create a new constitution and a new government. Article 5 delegates are commissioned to only vote on an amendment pre-approved by their state legislature, thus leaving sovereignty in state legislatures, not delegates.
The Article 5 single-issue Countermand Amendment will empower state legislatures to address egregious wrongs suffered by the people that the federal government refuses to remedy, safely remedy those wrongs one issue at a time, provide a powerful tool for the states to peacefully counter federal encroachment on states' rights, establish a proper workable balance of power between the states and the federal government, cause the federal government to respect the states as partners in government, not subjects to federal mandates. State legislatures, as elected representatives of the people, are and must remain the most powerful governing body in our constitutional republic.
Article 5 does not allow the states or delegates at a convention to write a new constitution. In order for the states to create a new constitution, they would have to secede from the Union, call for a convention, independent of Article 5, create a new constitution, and form a new government. Under Article 5, states already have sovereign authority to amend the Constitution to protect our liberties, so secession is not necessary. The Countermand Amendment empowers state legislatures to affirm and secure their sovereign authority peacefully, without changing our inalienable rights and protections in the Constitution.
In 1787, 13 state legislatures created the Constitution and federal government. The government did not create the states. Their purpose was to form a federal government that would serve and protect the states, not rule over them. Before deliberations started at the convention, wrangling began on how the states would vote. The largest states wanted voting by population. The smaller states demanded one vote per state delegation. The smaller states won, giving us a Republican form of convention. The thorniest problem on how to retain their sovereign nation-state independence was answered in Article 5. Under the Articles of Confederation, amendments to the Constitution required unanimous consent by the states. One state could and did hold the others hostage. Under Article 5, ratification requires only 3/4 of states, thereby removing the possibility of gridlock by one state. Sovereignty remained in the hands of the state legislatures. Under Article 5, state legislatures are the deliberative body, not delegates they send to a convention. State legislatures define their sovereign authority under Article 5 for themselves and future generations of legislators, and must not abdicate it. Not to Congress, not to the courts, not to the executive, not to government and non-government agencies, not to regulatory agencies, not to governors, not to delegates at a convention. Current Article 5 groups are ignoring critical constitutional issues that diminish, even abdicate, state legislature sovereignty. Other Article 5 group strategies, by relying on the following, make it impossible for future legislatures to retain their sovereign authority. Legal precedents will not guarantee that an Article 5 convention will be governed safely. Convention experience before the Constitutional Convention can't cause a convention to be conducted safely. Political and historical experience will not guarantee that deliberations at an Article 5 convention will be productive. 535 politically charged delegates summoned by Congress will cause mayhem at an unbound amendment convention. Only a delegate resolution, pre-approved by state legislatures, will assure a safe, quick, as short as 7 days, and successful Countermand Amendment convention.
State sovereignty was the most important issue at the convention. Convention rules were proposed by Delegate George Wythe even before deliberations by the delegates started. Proceedings were to be secret, guards to be placed at the doors, credentials required for the entrance, each state to have one vote at the convention. 30-plus previous state conventions did not decide this question for the founders. Politics did. It will have to be decided again and again at every Article 5 convention. The Countermand Amendment, Delegate Resolution, requires the convention be organized as a republic. Each state will have one vote. All decisions will be decided by a simple majority vote of state delegations, not by the population of states. Polls of delegate positions not recorded. Delegates speak only twice. Delegates pay strict attention, and remarks are addressed to the President.
"73 delegates, one for each member of Congress, were summoned by the Confederation Congress to the 1787 Constitutional Convention. This will be the pattern of summoning delegates from the states to be followed at every Article 5 convention. Up to 535 politically charged delegates will be summoned by Congress and appointed by state legislatures to an Article 5 Amendment Convention. Issues that they will have to decide include how the convention should be organized, what rules of order will be used. Will Article 4, Section 4 be used to guarantee the Republican form of convention? Will one vote per state be adopted at the convention, or will voting be based on the population of each state? Will majority rule be used at roll calls? Will delegates be bound to their legislatures? What subjects and sub-subjects, even sub-subjects, as some groups have advocated, will be considered? How will the delegates identify federal encroachment on states' rights? What delegates will decide the final text of a proposed amendment? The Countermand Amendment Delegate Resolution will answer all of these questions and assure that the convention is safe, quick, and successful according to the collective will of state legislatures. A pre-approved Countermand Amendment text with Delegate Resolution adopted by 26 or more states will prevent 535 politically charged delegates from delaying and disrupting the convention. The Countermand Amendment Convention can finish its work in as little as 7 days. Countermands and rescissions of laws and rulings that encroach on states' rights can begin immediately after ratification, maybe 12 months from now. With the Countermand Amendment Delegate Resolution, there will be no drawn-out deliberations or wrangling at the convention. Other Article 5 amendment proposals could take 12 months or longer, and there is no guarantee that the 535 politically charged delegates would ever find agreement acceptable to 38 ratifying states. The largest states would dominate the convention unless it was organized as a Republican form of convention as guaranteed in Article 4, Section 4. It could take years before any ratified amendment from other Article 5 groups becomes effective in reining in the federal government. The Countermand Amendment solves all of these convention problems and almost every other issue relating to federal encroachment on states' rights, including prohibiting Congress from excessive or deficit spending.
The nonpartisan Countermand Amendment provides tools with teeth for state legislators. The Countermand Amendment has tools with teeth for state legislators. Intentional violators of the provisions of the Countermand Amendment are subject to criminal prosecution. Government officials and employees are subject to criminal prosecution. Elected officials, non-government workers, and entities. Enforcement can be by the federal government or by state governments under state laws in the absence of federal prosecution after 90 days from the date of the alleged violation. Multiple prosecutions by multiple states for the same alleged crime are prohibited.
The Countermand Amendment and individual state nullifications complement each other. States can exercise individual nullifications with or independent of the Countermand Amendment. With countermands, the states can safely and peacefully define and protect their unenumerated rights in the 9th and 10th Amendments. When a law is rescinded, it automatically becomes an unenumerated right and constitutionalized for the states. Countermands are an act of nullification, but with countermands, the states do not have to stand alone. The federal government will not be able to enforce a rescinded law in the future. "34 state legislatures must complete applications directing Congress to convene the single-issue Countermand Amendment Convention. When 34 states complete their applications, Congress is mandated to call for the Countermand Amendment Convention. State legislatures reserve sovereign authority to convene the Countermand Amendment Convention on their own if Congress delays calling the convention. Applications must be near identical between calling states, especially 1. The title, Countermand Amendment Convention, 2. the insertion of Article 4, Section 4, and 3. the 60-day notice on Congress for calling the convention. Article 5 applications for the Countermand Amendment are going forward in dozens of state committees and chambers. 34 state legislatures must complete applications directing Congress to call for the Countermand Amendment Convention. 38 states must ratify the Countermand Amendment. 26 or more state legislatures need to approve the same or similar Countermand Amendment Delegate Resolution to assure a successful convention. Delegate Resolution should be adopted by legislatures before the convention convenes. The Delegate Resolution is a contract between the legislature and their delegates who are going to the convention. It avoids possible conflicts with Article 1, Section 10, prohibiting interstate compacts between the states without Congress's approval, which we want to avoid. The Countermand Amendment Convention is now safe, quick, maybe only 1 week, and successful. Only 3 documents are needed to assure that the Article 5 single-issue Countermand Amendment Convention will be safe, quick, and successful. the Countermand Amendment text, the application, and the Delegate Resolution. Go to these links and read the information that is there so you can have a complete understanding of how important this Countermand initiative is. Use your pause button to read Section 1 and Section 2 on the screen of the Countermand Amendment. Use your pause button to read Section 5 and Section 6, which are the enforcement clauses in the Countermand Amendment. We are making constitutional history with the Countermand Amendment. Thomas Jefferson said, "God who gave us life gave us liberty. Can the liberties of a nation be secure when we have removed a conviction that these liberties are the gift of God? Indeed, I tremble for my country when I reflect that God is just, that his justice cannot sleep forever." If you are a state legislator, take the lead in your legislature by sponsoring the Article 5 Countermand Amendment Convention. For those of you who believe that we are losing our protections in the Constitution, join us in this initiative. Be part of this historic, nonpartisan amendment that can permanently restore our Constitution, Republic, and states' rights. This is the most important constitutional event since the 1787 Convention.